Good morning, Your Honors. Jason Saunders from Gordon & Saunders. I'm representing Daniel Brown in this matter, and I'd like to reserve 3 minutes, please. That black man has a gun. We're here to decide today whether that phrase alone with nothing else is sufficient to raise justification for a Terry stop, that criminal activity is afoot on a well-based suspicion that something is happening. We are also here to find out if indeed that's not sufficient, whether police can then follow for 3 or 4 blocks, actually Metro Transit police follow for 3 or 4 blocks based on that report alone. And then finally turn the wrong way down a very busy street, 4th Avenue downtown, and finally engage their lights and Mr. Brown runs. Whether that combined with the fact that someone said, that man has a gun, justifies the stop. What's interesting in this case is nowhere in the testimony, nowhere in the exhibits, nowhere is there any officer that said, you know, at the final point when he began to run, I suspected he must have been engaged in criminal activity, and that criminal activity was nothing in the record at all. So let's start with Florida versus JL. We know that the simple report by a tipster that black man got a gun is insufficient for reasonable suspicion to do a Terry frisk. We know that in that case, there was a man waiting at a bus station, very similar to this case where it's an anonymous tip, and the tip is simply, he's got a gun.
So say we agree with you that the tip is not enough. We've got the tip plus the flight, as you already acknowledged. So can you explain why that's not enough?
I will. Let me just say one thing about Florida versus JL, and that is there was no indication that that tipster thought there was a illegal conduct as well. So that's what we have in this case. Let's talk about Wardlow, because we'll just jump right into it. That seems to be the case that will decide Mr. Brown's fate. Wardlow was a case where there's 4 patrol cars going in a caravan to actually go into a high crime narcotics area to look for not only drug dealers, but also look for lookouts and to actually stop the narcotic transactions. So these police officers had a job to do, and they went out to do that job. When they located a man with an opaque bag leaning against the building, they were looking at him when that man looked up and said, "Oh, cops," and ran and instantly fled. And then he went through down the alley, through a garage area, and was finally apprehended. And the court, it's a 5-4 decision, both the concurrence as well as the majority. Every justice determined that is a totality of the circumstance test. It's not a per se rule.
But basically there we have high crime and flight, and here we have tip of gun and flight. So why is tip and gun and flight not as suspicious as high crime and flight?
Because there's a little bit more than high crime and flight. There's high crime, opaque bag, and instant running. Here we have...
Yeah, the question here seems to me to be also the Washington gun laws.
Yes.
Right?
Right.
And
exactly.
So it's legal, as I understand it,
yes,
to have a concealed weapon or a weapon in Washington if you have a permit, correct?
Correct. And if you don't have a permit, if they have a reasonable reason to stop you and ask for your permit and you don't have it on you, it's a civil infraction.
Right.
Right, but that's the extent of it. But otherwise, you're allowed under the Constitution, as well as any statute, to have open carry any gun you'd like. And the only times when that would be prohibited is if you actually display it and cause a great safety alarm to citizens, or you actually try to intimidate with that gun. But we don't have a report of either.
We have a gun,
yeah.
But then they decide to go down the streets up here and look for him after they've got the tip.
Right.
I assume there's nothing wrong with that. In other words, there's no constitutional prohibition if you get a tip and you're sort of thinking, well, I wonder if something's going on, better get down there and check it out. Up to that point, you haven't suggested the officers have done anything wrong, right?
Well, they're following a man with no indication that he's committed any crime.
But they're
Is that
driving.
illegal?
No, no.
I mean, they can drive down the street, right?
They
There's
can drive
nothing.
down the street. They can drive down
They
the
can
street.
follow somebody for a long time.
They can. And what's important in this case too is
Can't
they
put a
did.
tracker on him, but they can,
Yeah,
but they can follow him.
But they did follow him, and they followed him for a long time. What's interesting is this man is on foot, and there's a patrol car stalking him, pursuing him for 4 blocks. And then the end action by the police officers, when they actually decide to turn on those lights, is to turn the wrong way down a very busy street. And then the fact that he runs at that point, they think, well, that's justification to stop him. But for what? What is the founded suspicion in criminal activity that is now in the mind of those police officers? They never testified to it, and the court never found that they had suspicion at that point to decide that he was engaged in drug trafficking, didn't have a concealed weapons permit, had maybe flashed that weapon and intimidated a citizen. No one testified to it. No suspicion was elaborated by police officers. They just stopped the man.
Let me ask you a different question. If you go back in time when Washington permitted medical marijuana, but not, personal use marijuana, and you got a call from the YWCA say, there's a guy down here, he has a huge bag of marijuana.
Right.
Would that situation have been different, where there was both the potential for legal and illegal activity?
Yes, especially for, a federal case, especially under the current administration, there could still be a case that could move forward if the prosecutors decided to, that he was in possession of an illicit contraband under federal law.
And the same would be true. Now we have new laws in Washington. If he has a big bag of marijuana, under federal law, would you say the same would be true? They could follow him and stop him and ask, see the size of the bag he has?
Right, yeah, that amount seems a lot for what you're allowed to carry under the law. I think this case is even more. I was thinking about the same kind of analogy. I was thinking this case is more like a man carrying 2 bundles of big bills walking down the street. He has every legal reason to carry 2 big bundles of money, but police, when they stop him, sure, maybe he robbed a bank and took it, or maybe he robbed some people who were leaving a bank, or maybe he got it from gambling, that was illegal. But when he's legally doing something, carrying 2 stacks of money or carrying a gun, you have no justification to stop him unless you think you have a well-founded suspicion that he actually engaged in illegal
There's no brandishing here, at least no tip.
No
It's
brandishing.
just he has a gun.
He has a gun. And the 911 operator made it really clear. It's like, well, so this person that you're talking about, did he point that gun at someone? Did he handle it? Or what was he doing with the gun? Did he do something wrong with the gun? And the person reporting second hand of this reporter said, no, he just had a gun. That's all I know. He just had a gun.
Was it no, he didn't do those things, or just I don't know?
I don't know.
Yeah, because we don't really know that he didn't. I mean,
Right.
maybe the idea that this person knew he had a gun does mean he brandished it. We don't really know one way or the other,
I have
right?
no idea. And that's what makes the tip unreliable. Under JL, and that's why it was so important to name that last fact, under JL, sure, you can say a man has a gun, but without that assertion that there's an illegality, then you cannot stop that person.
I'm just still not sure about your answer to the flight, though. So your hypo with the 2 big bundles of money, if that person keeps walking calmly and the police are following and keeps walking calmly, then maybe that person has no suspicion. But if that person starts running then when the police are there, isn't that more suspicious?
It is more suspicious, but standing alone, once they stop that person, in their mind, they have to announce what that suspicion is. At that point, I thought that man must have
Well,
robbed
why?
someone.
Isn't it an objective standard? Why do they have to announce what they think it is?
It is because especially if you look at Wardlow, Illinois versus Wardlow, you look at a 5-4 decision, and there was a split 5-4 on whether those facts of a high drug narcotics area, opaque bag, and an instant run was sufficient. 5-4 decision on that.
Yeah, but it's still, whatever the answer is, it's an objective, right? I mean, what the actual officer has in his or her head doesn't answer the question of whether they can stop him.
Well, I think it does have to be a well-founded suspicion that something was going wrong, and I mean...
So, like, why can't it be maybe this person has no gun permit?
Well, I will argue at this point for a concealed weapons permit, that was never argued below and it was waived, because that
Well, I
was
guess
never
the question is, we never got to that because I'm reading the district court's opinion. They say he attempted to contact defendant, but then later the testimony of the deputy is he started following him, he activated the lights, and then Brown ran. So there was no actual verbal contact with the individual, right?
There was
no sort of like,
please
stop, I want to see your gun permit.
Exactly.
Would you agree that that the officers would have had the right to say, stop, I'd like to see your gun permit?
Yes.
And then if he'd run after that, would you have a different situation?
Yes.
Your time has expired, but I'll give you some time for rebuttal.
Thank you, Your Honor.
Good morning. May it please the court, Charlene Koski for the United States. The district court correctly found that the totality of circumstances in this case established reasonable suspicion. Those circumstances included that within minutes of receiving a 911 call reporting a man fitting Mr. Brown's description with a firearm in front of the YWCA, police observed him walking away from the YWCA, looking back over his shoulder at police. When police started to follow him, he picked up his pace and repeatedly looked back over his shoulder toward them. And then when police activated their emergency lights to follow him the wrong way down a one-way street, he began to run.
Okay, so let's stop there and take each of those things. They get a tip from the YWCA that there's a guy with a gun, right?
Well, I would clarify, and I would just point you to ER 127, the tip. The 911 call came in as, they said, one of our residents just came in and said they saw someone with a gun at 3rd and Virginia. Right. And then that was relayed to police dispatch at the bottom of ER 127. She said she saw someone with a gun. So it actually came in as more than just he has a gun. It suggests that she actually did see the person who notified saw it.
Let's assume that this anonymous tipster who doesn't want to talk to the police but goes through the dispatch or the desk attendant at the Y says, I saw a man with a gun.
Yes.
Right? Okay. In Washington, is there anything illegal about, in and of itself, carrying a gun?
So it's not unlawful on itself to have a gun, but it's unlawful to carry a gun in certain ways, including it is unlawful under RCW 9.41.270 to carry a firearm in a manner or at a time and place that warrants alarm for the safety of others.
Do you have any evidence? I've read this transcript, which is pretty opaque, from the officer, from the YW person to the dispatcher. There's no suggestion that he brandished the gun, correct?
Oh, well, it's reasonable to think that she saw it.
She saw it.
So but it doesn't have to be brandished. It can just be carried or displayed or exhibited in a way that causes alarm for others.
Well,
and it's in front of the YW.
For many people, just seeing a gun would cause alarm, but we have to deal with the Washington law. So you're embellishing with, well, maybe she did this.
Well, no.
But the fact is, a person saw this gentleman with a gun, right?
If he bent over to tie his shoes and she saw a gun in his back pocket, is that in violation of the law?
Possibly not, but taken with the fact that this is in front of a women's shelter, she came in and she felt alarmed enough to notify the staff, and the staff felt that within a minute notified 911 and described the person over the phone and said, this is what we've seen. Now, you don't have to show that he actually violated the law at that point. You just have to show reasonable suspicion.
But what's the reason suspicion of what we have? They really have a good description of his shoes and all that stuff. So I don't think there's any doubt that the person that the hearsay tipster, anonymous tipster, saw was this guy with the shoes. Okay, we have a good connection there. But if it's legal in Washington to carry a gun, what is the reasonable suspicion at this point someone has a gun?
Well, I think that the reasonable suspicion would be that perhaps this gun was displayed in a way that caused alarm for others.
Well, the reasonable suspicion is, but you don't know that. The only thing we know is that this person saw someone with a gun.
and was alarmed enough to notify the employee who was concerned enough to call 911, which is an emergency response system, which police are obligated to respond to.
Right, so you're sort of reading in that, well, because they called in, I mean, a lot, as I said, it's equally probable, and it doesn't raise suspicion, that most people probably don't know that you can carry a gun in Washington. I mean, I don't think it's necessarily common knowledge that you can get a permit and virtually anybody can have a gun in Washington. So why do you read in, my problem is reading into the facts something that's not there.
Well, I think that the case law allows for police officers to treat 911 calls. I think that actually is a very important distinguishing factor between what happened here and JL. And I think that Navarrete is an important case to look at that the district court did not cite, and I actually don't think it was even brought to the district court's attention. But you do have an entire line of cases that look at the reliability and the special factors that go into 911 calls that allow police to rely on them to assume that there's an emergency here that they need to respond to. At least enough to approach the person and ask, do you have a firearm? And, you know, if he says yes, then to ask for his permit.
AL was an anonymous caller to the police. What, are you saying it wasn't a 911 call? It was some other kind of call?
Yeah, it was just an anonymous tip and they didn't know who made it.
Because the person at the Y says, well, later she says, I don't like police, so she doesn't want to get involved. And so it's reasonable if she reports this to the desk that who are they going to call other than 911? I mean, there's not some other place you can call.
Well,
so
they made the call.
Pardon?
But the fact that she made the call at all, I mean, she didn't have to make a call at all, but she did, and then police are involved.
But she's not anything other than a conduit, correct?
Correct.
And she was not, you know, the other person didn't, she said she didn't want to get involved. Right?
Correct. You could hear her in the background, though, confirming details, right? She just didn't want to give her name.
And saying, I don't want to get involved and that sort of thing.
Correct.
So I really have trouble distinguishing this from JL because the police never made contact with him. And would you agree that actually you don't have any obligation to, if you see a police officer, you don't have any obligation to stop and act respectful?
Well, if they approach you, you can
had
decline
they
to talk
approached
to
him,
them.
They turn on their lights, but he's walking down the street.
They had not yet stopped him.
Right, they had not stopped him. They had not asked him, hello, do you have a permit? Which we will see in the next case. So at this point, maybe Justice Stevens was a little prescient talking about African Americans who have some fear of the police, and this was decades ago.
Well,
why if you see a police officer and you don't want to talk to him, it seems to me you have a right to run or leave.
He didn't just run, right? The officer also testified that he was looking back over his shoulder at police and acting suspiciously even as he walked away. And all of this happened within 10 minutes. Right. The dispatch was 9:14. He was in custody at 9:20 or 7:24. It was in like a 10-minute period.
But he doesn't know that there was a 911 call. I mean, the running, so
defendant,
Brown's mind, the fact that it all happened in 10 minutes is sort of neither here nor there, right?
Correct.
And he only knows that there's a police car out there.
Correct.
And then if the lights are flashing and he's like, whoa.
But it's the police officer's objective, like it's what they saw, what they knew, that we look at it for reasonable suspicion analysis. And if and there is a case, United States versus Garcia, the name is United States versus Garcia. It's a Ninth Circuit case from 1975 in which there was an illegal stop and the suspect ran, and this court held that but for causation, unless it was the police officer's intent to cause that person to run, it doesn't taint the stop. And once he runs and they have cause to stop him, they can stop him at force. They can use firearm to tell him to stop. They can put him in handcuffs. And this court's decision in Washington v. Lambert, which is a 1996 decision. And so there's nothing unlawful about what happened here. There was no intent to cause him. They weren't trying to get him to run. They actually, if you look at the record, it establishes an objectively reasonable basis to stop him, at a minimum to ask if he has a firearm. And then if he had said, yes, I have a firearm, they could have asked him to show his permit. And if he didn't have his permit at that case, they could have gone from there.
But they need to have reasonable suspicion at the time they stop him, right?
Correct.
So what is the reasonable suspicion at that point?
At that point, as the district court found, it's the totality of the circumstances. They have
But what is the crime they have reasonable suspicion of?
I think it's reasonable to suspect at that point that there had been an unlawful display of the firearm. At least reasonable suspicion, whether he did it or not, whether the reporter was
What's an unlawful
overreacting.
display of a firearm if you don't have any facts to back it up?
Displaying it in a manner that caused alarm to other people. I mean,
Is that based on it being a domestic violence shelter?
That's one of the circumstances. The YWCA is a shelter. The woman who reported it was a resident who lived there. He displayed it right outside the front door, or she saw him with it right outside the front door.
There's no suggestion he was inside the shelter or had a threat to the desk clerk or anything like that.
There is no active threat in this case.
If it was a McDonald's, same facts, but it's the McDonald's employee who calls the police, we don't have reasonable suspicion, but
I wouldn't say that. I think it's one factor, and I think in this case, it is a compelling factor. If you had the same circumstance, there's always a risk that the person who notifies police that someone has a firearm is overreacting. That's always a risk. But that doesn't mean that the police are unreasonable for responding to that concern and finding out if there's anything to it.
I'm just trying to figure out, though, if you can really have reasonable suspicion that it was brandished in some threatening way. Maybe you have suspicion that the person doesn't have a permit because they're running, but I don't know if that's a reasonable suspicion in Washington when anyone can get a permit, or almost anyone, not anyone, but
Many people.
Many people can get permits, not everyone. And
but it seems like you're not arguing that the reasonable suspicion was that you lacked a permit. You're arguing that the reasonable suspicion was that it was brandished already.
Yes, and not having a permit is a civil infraction. And running without, you have to be able to stop, you have to show your permit if you're asked to do it. Not having your permit is a civil infraction.
Correct.
So
But
yes, the argument here.
They never told him to stop. They never used their speaker, their loudspeaker, anything.
No, and again, but then this happened just within a few minutes. So the officer followed him, waiting for someone else to show up for backup. And as soon as backup got there, they followed him. They didn't really have an opportunity to tell him to stop, because before any of that happened, he went down a one-way street, they turned on their lights, and he ran. And at that point, you're just responding to the flight. And I think that all of the factors here taken together get you to a totality of circumstances. It was reasonable to suspect that he had displayed his firearm in a way that caused concern for others. And at the end of the day, if the person who called in was not willing to cooperate, if she didn't have a statement, if it turned out that she had been mistaken, you go from there. But we're just at reasonable suspicion at this point. They don't have to know that he actually did it. It just has to be reasonable to them to suspect that he did.
What are they going to learn? What are they going to learn from stopping him that's going to tell them more about whether he brandished the gun back at the YWCA?
I think when they stop him, they would ask him if he had a firearm. I'm guessing, but it would be reasonable to stop him and say, do you have a firearm? If he said yes, to ask him if he had a permit for the firearm. And if he doesn't, then to cite him or to do further investigation. Depending on however he responded to that question, it would go from there. So, do they have, could they have frisked him at that point? If he's running, yes. If they have concerns for officer safety, yes. There were so many different hypothetical situations that could come into that depending on his response. But it's certainly reasonable for them to stop him. They did not have the opportunity to do that because he ran. And once he ran, combined with all the other circumstances, you do have reasonable suspicion.
So that turns it into a rule of when the police are flashing, you better not run. In other words, it's what I worry about is that we're turning the cases into saying that you have to stop and talk to the police even if they haven't even asked you.
Well, you have much more than that.
It's at odds with other case law that says, look, you don't even have an obligation to give them your ID, and you don't even have an obligation to talk to them, and you can run.
Well, the case law is that if you run, the police, that heightens it, right? You are certainly taking risks by running. And there is case law that puts some protections in place, and that is the Garcia case that I cited earlier. If the police are doing this intentionally, if their purpose is this is all a ruse to get you to run so that they can then stop you, then that's not lawful. But what the police did here was lawful, and they had more than just his running. They had the way he was looking over the shoulder combined with the information that they had received from 911. And I think all of those circumstances together, the district court correctly found that the officers had reasonable suspicion.
Thank you. Will you put 2 minutes on the clock, please? You have 2 minutes.
Thank you, Your Honors. Just to start briefly with the cases that the government has cited. I don't see that in her briefing, and I also don't see a 28J letter for supplemental authority. It's not before the court, so I can't address it because I don't know about those cases whatsoever. But I will once again talk about JL, just that you need that well-founded suspicion that something is going on. And in this case, there's a possibility that something might have gone on. Maybe there was a brandishing or in an illegal way, but there's no indication of any illegality by that person who gave the tip. And that's just like jail. You need that kind of connection, gun with something else, to stop a person. And this wasn't a simple, excuse me, can you stop? I'd like to know what's going on.
So why doesn't it matter that it's a domestic violence shelter?
Well, you know, that wasn't argued below, and it's waived, but there's no indication that he was stalking or waiting or doing anything in front of that, except that he was present. The only indication was that he was present outside of that building, and certainly anybody can walk by that building, and without any assertion by the tipster that he was doing something illegal, under JL, you can't find that you can stop a black man because he has a gun.
Well, why, actually, if anybody that you know, the police know has a gun, like they see it, or somebody says, hey, did you see the guy with the gun? Wouldn't the police have a right to stop that individual to say, do you have a permit?
I don't think so. And I was trying to look for a case that stands for one way or another, but I did not see it. But I know for a fact that there are, especially when it comes to driving, it's a permit kind of thing. You have a privilege to drive. Sure. And police cannot just pull people aside and say, do you have a driver's license? And police cannot, if you have a trip permit, pull you aside and say, is that a valid trip permit? Prove it. So, this is a privilege that you have to have a permit for, but unless there's a reason to stop that person and ask them questions and investigate and then determine that he doesn't, you can't stop that person just to find out whether or not he has a permit. Thank you.
Thank both counsel for your very helpful argument this morning. United States versus Brown is submitted.